what you're charged with is manslaughter as a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison with a possible fine up to $10,000. 22 CR 10260, State of Texas versus Maria Antoinette Neely. We're going to have parties announced for the record for the state.
Jason Garrett, Your Honor.
Defense?
Meredith Chacon for Miss Neely, Your Honor.
And are you Miss Neely?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor, and I have signed the discovery acknowledgement. And before we begin the plea, I just need to put one short thing on the record with my client, if that's
All right. So the court will find that the state is in compliance with discovery and you may put on the record what you wish.
Miss Neely, you had originally filed a motion to have a different attorney appointed back in November. Are you asking the court to disregard that and have me continue as your attorney today? And are you satisfied with my representation? Yes.
Oh, thank you. All right, Miss Neely, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Neely, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
And did you understand what you're charged with is manslaughter as a second-degree felony? The range of punishment is anywhere from 2 to 20 years in prison with a possible fine up to $10,000.
Yes, ma'am.
And the repeater, Your Honor, we're proceeding with that.
All right.
Okay.
And so with the repeater, if it's proven, then that makes it a first-degree felony. The range of punishment for that is anywhere from 5 to 99 years or life with a possible fine up to $10,000. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and rights to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally insane at the time of the offense?
Yes, Your Honor.
Ms. Neely, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, you agree that you've been previously convicted of a felony for purposes of enhancement. Punishment is be assessed at 8 years in the prison. There are no applications, and the state will take in consideration 2022 CR 10259. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, State Exhibit number 1 with all of its attachments, Your Honor.
And I've gone over that with my client. We have no objection, Your Honor.
Ms. Neely, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence States Exhibits 1 and attachments. To the repeat offender enhancement allegation, how do you plead? True or not true?
Sure.
Reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea of true and also based upon States Exhibits 1 and attachments. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client's taken responsibility. She also has a federal case that she has to take care of. And when she finishes her sentence on this case, she'll be going there. So we'd ask for credit for time served.
All right. And is the felony case, I'm sorry, is the federal case still pending?
No, she was on supervision, so it's going to be revoked, I believe.
All right. I mean, I could ask that this run concurrent with that.
If there's a
but,
way to make that happen, that would be excellent. We would ask for that.
I can tell you because I guess technically you haven't been revoked on the federal case, even though I say run concurrently, it's really up to them whether they will do it or not. Do you know what the case number is?
No, we don't.
All right. If the court is,
It's like in different cases.
all right, the court is given the case number, the court, of course, will add that and have it added into the judgment. But for now, the court is just ordering that it run concurrent with the federal case. All right, is there anything else from either side with regards to sentencing?
On the state, Your Honor.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. What are you planning on doing with the rest of your life? That's something that you need to be thinking about, unless you want to be the person who, when somebody comes to some institution, says, how does this place work? And they say, oh, you need to speak to the oldest person here. And they say, who is that? They're like, oh, we call her Grandma Antoinette. Or either with you, they may say, we call her Queen Antoinette because of your middle name. And then you find out you're the oldest person at the prison. So you had better start making changes, because it's not going to go well if you don't. You understand? All right, good luck to you. Court is calling 2022 CR 7283, State of Texas versus Christopher Brent Davis. I have parties announced for the record for the state. For the defense.
For Mr. Davis.
Suzanne Kramer, also for Mr. Davis.
All right, Mr. Davis, you entered a plea on May 7th of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt. You're coming open to the court. Have both parties had a chance to review the report from probation?
Yes, Judge.
Yes, Judge.
Any objection, state?
No, Your Honor.
Defense?
A couple of corrections, Judge.
Yes.
Regarding his discharge from the Navy, it was stated in there that it was less than honorable. I think his actual discharge was a general under, what's it called? Under honorable.
Okay.
General under honorable, not less than.
Okay.
And at the very end where he states a few things he wanted you to know, he referred to something that happened to him at age 5, but a subsequent conversation with his mother that was determined to have happened when he was at age 2.
Okay. All right, any witnesses?
Not from the state, Your Honor. We just have an argument.
Just Mr. Davis, Judge.
All right, could you raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do have a couple other witnesses. Can we take them first, Judge?
Sure.
Thank you. I'm sorry.
All right, call your
Let's
first
go
witness.
Edith Davidson.
All right, Edith Davis.
Stand over here.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you're going to need to keep your voice up so the court reporter can hear. Could you state your name for the record?
Edith Davis.
All right, defense.
All right. And Ms. Davis, are you Christopher's mother?
I am.
All right. And I think you may have heard me state just a minute ago about something that happened to Chris that you said happened at age 2.
Yes, sir.
And can you explain to the judge what happened and how that turned out?
So our babysitter was leaving. We were looking for a new sitter. My husband's getting ready to go to Korea. We found a lady that was in the neighborhood. She had 2 other children that were a little bit older. I had come early one day and found their children throwing rocks down on my children. Christopher was almost 3, not quite. Then when I got, found out she was giving them dog treats for cookies for their snack. And I had known that both my kids, Kristen was disabled, but Christopher, very active, had a gotten very, very afraid of when I was cleaning house. I didn't understand why, but when I had talked to my daughter, she told me that the kids would take the vacuum cleaner and suck on Christopher with it and tell him that he was going to suck him up and he would suffer. So when I saw what was going on at the house, I immediately removed him from the house. I found my next door neighbor was going to take care of them for me. So it took a little while to get him a little bit more calmed down, but it was pretty traumatic for them.
And did you have a statement that you wanted to read for the judge?
I do. That's okay.
All right. State, do you have any objection to the reading of the statement, or would y'all? Well, I mean, it's technically it's a narrative, but if you all want her to read from it, or counsel, if you want me to read it,
I have no objections.
all right, you may proceed. That's okay. If you want to, I can actually read it.
Thank you, Judge.
All right, you're welcome. No problem. Just give me a moment. All right, any further questions?
Do you have anything else you'd like to tell the judge? Okay, nothing from Ms. Davis.
All right, thank you.
I'm going to call Michael Davis.
All right, Michael Davis. Does anybody have any Kleenex?
I'm trying to get on, Judge. I can't reach.
Thank you. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michael Davis.
All right, defense.
All right, Michael, are you Christopher's father?
Yes, sir.
We've had some conversation about this scenario, and it's my understanding that you feel like maybe you could have done something different and would have avoided all this. Can you explain to the judge what you're feeling?
Yes, ADHD runs in our family. I was never diagnosed, but I've had issues with it my entire life. I'd learned to deal with it. When Christopher finished high school, he quit taking his medication. And when he joined the Navy, if I had called the reservist office and told them that he was ADHD, because I know he didn't tell them, they would either rejected him or kept it, had him take his medication. His whole life would have been different. One phone call, if I'd made it, wouldn't be here. So, love my son, I know he did wrong, but that's all I've got, ma'am. I'm sorry.
No, I appreciate you coming in to testify.
I don't have anything further, Judge.
Any other questions?
No.
All right, thank you so much.
And Judge, at this point, I just have Mr. Davis.
All right, so raise your right hand for me. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Christopher Brent Davis.
All right, defense.
All right, Christopher, what is it that, other than what you already stated in the PSI, what is it that you would like the judge to know before she decides what your sentence ought to be?
Your Honor, there is no explanation. There's no rhyme or reason. Nothing would be able to be justified as far as what my actions did. There's every day that I live with regret because it's not only one person I hurt several people, including my own children, my own biological children. The only thing I can ask is for forgiveness from them, and I will accept whatever consequence that you seem as punishable, Your Honor.
All right.
And Judge, this is the part where I do, like I tell my wife, if I tell you something from here on out and that you can accept it two ways, one to make you mad and one to make you not mad, I mean the one that makes you not mad. Okay. So, question that we have is what's appropriate punishment for this type of case for
All
Mr.
right,
Davis?
I'm sorry, just 1 second. State, you don't have any questions, do you?
No.
All right.
All right.
All right, thank you for giving your testimony. And so the range of punishment for this offense is 5 to 99 years or life.
That's correct, Judge.
So, State, what are you requesting?
Do you want my request and my argument, or just my request, right?
Your request.
You're asking for life, Your Honor.
All right. So they're asking for life. Defense, what are you going to be asking for?
Judge, we're asking for 20.
All right. So now, state, I understand why you're asking for life. Defense, I understand why you're asking for 20. So, one, I'm not going to sentence him to life. I've taken in consideration his testimony. I've taken in consideration the testimony from both his parents. And I want the parents to know, at some point in time in life, your actions are not the cause of your child's actions. Because how old are you?
38.
All right, so he's 38. At some point in our lives, when we're making our decisions, no matter what happened in our past that was horrible for us, or maybe our parents made a mistake in how they raised us, at some point, your actions are your own. All right, so I'm not going to sentence you to life, but I'm not sentencing him to 20. It's an egregious offense.
And if I may offer some perspective on that, Judge, that's what I
Yes.
intend to do. So we agree it's egregious offense. He agrees it's an egregious offense. It's something that went on for about 6 or 8 months from what we can tell from stipulated evidence. And yet the same day that we were pending, that we actually entered our plea, there was another person pending who's had a death of a child, injury to a child causing death. And the very next day, this same prosecutor's office, same prosecutor,
I'm gonna object to this
offered
line of,
them 18 years.
All right, okay, so here's the thing. Defense attorneys, you all know that sometimes people can be at the Bexar County Jail or at the prison. Sometimes there are people at the prison for murder, they get 5 years. Somebody else at the prison for murder, they get 30 years. Every case is different, and there's a reason why people are given certain times. And there are reasons why sometimes this court follows a plea, sometimes that I do not follow the plea. Now, what I'm telling everybody, the state has asked for life. State can ask for whatever they want. I've already told the state, I'm not giving him life. So the argument about what they did in other cases, that's not an appropriate argument. We're here for this. Now, if somebody wants to make an argument that the same fact scenarios, as we would call it in law school, that the case is on all fours, if there's another case that's on all fours with this case, where the state gave somebody 12 years or 10 years, then we need some explanation, because maybe things are not being done fairly. So if you can present a case to the court that's on all fours with this case where the state made an offer of something less than life, I think it's relevant. I'll hear it, because maybe something else is happening in the office.
Well, Judge, and I would offer you something on that. I think it's on all fours. I don't know whether it's on all fingers and toes, but there was a case in the 227th where the fellow was charged with continuous sex abuse of a child, same as Mr. Davis. He was allowed to plead to aggravated sexual assault of a child, same as Mr. Davis, but he was given 12 years
All right, so
for a 4-year-old child.
So let me ask you this. Was that a case where you had a defendant who's alleged to have pretended to be a juvenile online and then tricked his stepdaughter into allowing him to engage in sexual activities with her by pretending if she didn't, the new friend that the defendant had created, life would be in danger?
Of course, Judge, I cannot offer you that, but they just, for selective prosecution purposes and sentencing purposes, substantial similarity, I think, is what they look for. And in this case, the same charge, same reduction, a 4-year-old instead of a 14-year-old, and this fellow gets 12 years and the state wants life. I know you said you're not giving that to them, but this guy gets 12 years in a different court, and Mr. Davis is looking at whatever you choose to give him. So that's the only reason I'm offering that, Judge.
Right.
And again, back to I'm not trying to make you mad.
No,
I don't want to visit my sins on my client.
No. Here's the thing. One, I don't get mad. I believe that everybody should be allowed their argument. I've been a defense attorney before. People should be allowed their argument. I've been a prosecutor before. People should be allowed their argument. I don't get mad. And what I can tell everybody, when you're in jury trial, if this were a jury trial, guess what? Defense counsel's state's closing arguments, that's not evidence. Evidence is the steps that I have. Evidence is whatever testimony I receive. Closing arguments that counsel do on both sides, that's spin. And hopefully the arguments they're making is in some form or fashion connected to the case that was just heard. All right, is there anything else?
No, Judge, I would just like to highlight, there is one other statement from Christopher in the pre-investigation report at the very last page. It states that he was the subject of grooming himself when he was around 12 years old by a 39-year-old. We've discussed this, and again, Judge, he's not of the opinion that it's any excuse for what happened, and he doesn't even really know if it went any any substance or predisposition for him to have done this, but it's just offered for the court for contextual purposes.
All right. So I want to let you know that I heard all of the arguments. I internalized everything. And these are very difficult cases. Anytime someone comes open to the court, it's very difficult. And let me just tell you why it's difficult. This is the type of case where everybody will say automatically it's a life case. Right? But I go on facts. I go on what I read. I go on everything. I go upon, experience I've had in dealing with specific cases. Because otherwise, if every case were a life case, then guess what? We don't even need to have a punishment hearing. It's just, this is what you did. We proved it. You get life automatically. So I look at everything. What you've done, of course, is something very bad. And people are going to be impacted for years to come, right? So sometimes when I consider what to send somebody to, I think about their age, I think about protecting of the public. And there are many things that I have to consider. Like, for example, is somebody going to allow you to be around children again? That's something I have to consider. Like, what age will you be where people will see you and they will not say, oh, that's a good catch. Let him babysit a child. Those are all things that I have to consider because part of my job is protecting the public. And I also have to consider evidence that's presented. I consider the stipulations that you stipulated to. So this is what the court is going to do. Court is finding you guilty. There's to be no contact with the complainant. There's to be no contact with any minor. There's to be Chapter 62 registration. Court is going to sentence you to 45 years. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Your Honor.
All right, we can go off the record. Here's the thing I want to let you know, just a second. I want to let you know that I appreciate the fact that you entered a plea to this, you entered a plea to it early, that when you came before the court, you didn't try to be wishy-washy on whether you did it or not. You are a person who truly took full responsibility for what you did. And I appreciate that you did that. All right, so, all right, you may proceed.
Do I start reading?
Yes.
Okay. Even after all you've done, after all of the activities you did, and all the messed up things you did to our quote-unquote family, I was able to fill myself with remorse, empathy, and sympathy for you. Now, don't twist it, because I still hate your guts and wish you the rest of your life in prison. Also, don't be expecting forgiveness out of me. You might be able to convince other people, but you won't get it from me. You ruined a lot, but don't go raising your ego because you thought you ruined my entire life. You've only ruined things in it. You got away with it you've also improved my life. You got me away from you and Ashley. You brutally taught me how not to be so naive. You got the rest of my family away from you and Ashley and into a safer place. But most importantly, you found a way to wind yourself in prison. Here's a small list of all the things you've done to me, starting with the bad. You've made me relapse many times, gave me PTSD. You gave me a sleeping problem, suicidal thoughts, plus 4 different attempts, depression, anxiety, paranoia and trust issues, problems with talking about my feelings, nightmares constantly, fear of using any bathroom, gender questioning, panic attacks, caffeine addiction, slight smoking addictions, not being able to make friends easy due to trust issues, and problems with family members. Here's the list of good things you've done in my life. You put me into a position where I was being put with people who actually care for me enough to take Wyatt and I as their own children. That's it.
Right, thank you. Is there anyone else?
Mother.
All right, Ms. Davis?
Yes, Judge.
All right, you may proceed.
So I'm not sure where to start or the things to say to you, but this is where I'm going to start. Almost 16 years ago, when we got married, you said you would never hurt me or my daughter, who was only a couple months old at the time, or any kids in the future that we would have together. And I believed you. As our marriage went on, you ended up breaking that promise. You made me believe that I was crazy, and to the point to where I had to see doctors, therapists, and I didn't have friends anymore. I tried to help you be a better person, and it made you mad. I had no real warning about who you were. I'm glad I finally realized it with the help of some friends that I did make, and I made it out 7 years later. I made it out before things got so much worse than what they already were. Separated, divorced, went to court for our kids. You made people believe that I was doing things to our kids, and I wasn't. You played mental games with me and would verbally abuse me as well. After everything that you put me through, all the tears and the 7 years, you had everybody still believing that I was doing all of this. But eventually, you were caught because you did it. Sorry. I've been angry, yelled, screamed, cried over everything, and I blame myself for it, for not being able to protect our kids. You're not half the person I thought you were. But after all these years, I realized that your actions say more about your character than they do about me. I hope that life gives you everything that you deserve and you live peacefully with your choices that you've made, because our children and I won't be losing sleep over you anymore. You are where you belong. I feel you not only need for me to apologize for things that you did to me, but to the rest of my family and to these kids. And I hope that you pray hard for that and that one day they can forgive you. But I also want to sit here and say thank you in a roundabout way, Chris, for everything that you've put me through, but because you've not only made me a stronger woman, but you've made me a stronger mother when it comes to protection of our kids. The kids have decided that they wanted to say something to you. Our daughter states that, to me, you were never really my father, only because you treated me like I was nothing, for always lying and never listening when I told you the truth, for robbing me of my childhood and making me have to grow up too quickly.
All right, excuse me. I'm so sorry. The defense has raised an objection. I'm going to sustain that objection. Thank you so much for coming in to give your statements.
Thank you.
All right, thank you. All right, thank you. 2024 CR 2468, State of Texas versus Lorinda Ann Tarango. Could I have parties announced for the record for the state?
David Martin.
Defense?
Marissa Giovanco.
And are you Ms. Tarango?
Yes.
Counsel, have you received all of the discovery?
We have, Judge.
Did you review it with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Ms. Tarango, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
No, Judge, we're going to proceed on the lesser included offense of assault causing bodily injury. Class A misdemeanor.
No objections.
All right, is that going to be family violence?
No, it's not.
All right, Ms. Tarango, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor?
Yes.
Range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to a $4,000 fine, and up to 1 year in the Bexar County Jail? Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do believe she
Do you
does.
believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Tarango, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, state is proceeding on the lesser included offense of assault bodily injury, and they're recommending deferred adjudication. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I do.
Counsel, are there any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for 1 year. There be no contact with the complainant and anger management. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Law for states one with the attachment.
No objections, Judge. I have gone over it with my client.
All right. Did you review the document entitled Waiving Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes.
Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. Reviewing States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, my client has no criminal history. She works for the U.S. Attorney's Office, is that correct? And she's been there for
10 years.
10 years.
She is an upstanding citizen and she made a mistake, with a
Y'all made a
teenager.
choice.
Absolutely. She made a choice and she understands that and is accepting responsibility for her choice. And we just ask that you follow the plea bargain, Judge.
All right, so what happened?
We were at a volleyball game and the child came, it all started off with the coach. And the coach's child was bullying one of the other kids. And I went down there to break it up. And anyway, the girl called me a bad word. So my husband at that point got up, we got up to leave. And I was talking to one of the parents. And well, they got up and they left and they came through where I was standing speaking to the other parent. And I made a bad choice.
Okay. All right.
Because she did call me another name again.
I understand. So you just can't do that. You understand?
Yes, ma'am.
And I see the game was forfeited because a lot of parents just left.
Yes.
All right. And the complainant, she's not related to you at all? This is the coach's child?
No, this is just another girl that played on the team.
All right. Well, I don't know when people will address bullying. My mom would address it head on. All right.
Well, I got in trouble for it.
Yeah.
And Judge, one more thing. The other concern is my client's daughter still does play volleyball. And so I believe there is the possibility and likelihood that they will be at the same volleyball game. She understands she's not to talk to this child. She understands she's not to, sit next to them.
She's just
or
gonna
talk
have to
them.
drop her daughter off and
Okay.
wait in the car.
Okay.
Sometimes these are consequences for our actions. So she'll have to drop her daughter off. And if anybody's being bullied, report it. And if that doesn't do it, because I'm assuming these are organized sports
Yes.
and they have higher ups. If there's an issue with the coach who's allowing the girls to bully each other, then you need to go above his head, or as they say, go above his pay grade. And sometimes when you throw the words in, well, I guess I'll have to get an attorney. That's usually when people stand up and listen. So if you put it in writing, I'm not telling you what to do, but I would put it in writing and say, this is what I witnessed. There's bullying going on. The coach is not addressing these issues. I guess after you, my next step is to contact my attorney. Then usually people pay attention. And I would also suggest that you tell them that you want to see their handbook, because they should have a handbook. All the organized sports are supposed to have a handbook like the schools do, what their rules are. And that way, when you send whatever letter you're going to send, you can go to a specific rule. And if they don't have a handbook, then they should. All right. All right. Do y'all want to speak of local probation?
Again, Judge, my client is an upstanding citizen who's been a government employee for 10 years and she's never been in trouble before. She is motivated, understands what she did was wrong. She is motivated to do anything that you ask of her. And we ask that you follow the recommendation from the state and to keep it at 1 year probation.
The 1 year's our recommendation.
Oh, see, but defense, since you told me to keep it at 1, I was leaning towards 6 months.
We're okay with that as well, Judge.
Well, you're gonna make an argument.
I reiterate all of my previous arguments, Judge. She will be successful, and I think this was a one-time mistake, and I think 6 months is sufficient.
Okay. That just turned on a dime. We should bring Mr. Cox in here. Mr. Cox, you want to join in the argument? State.
And I do have to tell you, the child I was defending was not my child. It was another child.
No, I appreciate when people step up. I think we all owe a duty. It really takes a village to raise children. My motto is always, if you see something, say something, not, act physically, unless you have to, because there's no one else around. All right. State, I know you're asking for 1 year. Do you have any objection? It is a misdemeanor. She doesn't have any priors. At least that's what's being presented to me. There are underlying circumstances with why this happened. Is there any objection to the court going below your recommendation for the community supervision?
In the courts.
All right, thank you. All right, and then, of course, if you are unsuccessful or if they feel it needs to be extended, it can be extended up to 14 months. You understand? Oh, wait a minute. Okay. Well, actually, more than 14 months. You can be extended for 2 years, okay? All right, this is what the court is going to do. The court is going to sentence you to 6 months deferred adjudication. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with the complainant. If there are still volleyball tournaments, which I'm being told there are, you're just going to have to drop your daughter off. You understand? And wait in the parking lot.
Okay.
And you can always do the audiobooks in the parking lot. There's always something to do.
And Judge, she does live in Brewster County. If we can transfer to Brewster County.
Where's Brewster?
Alpine.
Where's Alpine?
These were my questions, Judge.
Have you ever heard of Sorrel State University?
Where's Sora State University?
Big Ben.
Okay, Big Ben.
Yes.
All right, awesome. So Brewster, can you spell that? I don't want to mess up.
BREWSTER.
Oh, it's like the women of Brewster Place. Okay.
Who are the women of Brewster Place?
Oh my God, you should be embarrassed for saying that. Although Zach doesn't know either. So
Thank you, Zach.
I got you.
there's going to be a transfer to Brewster County. I'm going to order anger management. Probation, is there anything else she needs?
No.
All right, is there anything else you need from the court to be successful in this probation?
No.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. I am not going to be the judge that is supervising your probation. Of course, probation technically was supervised, but if there's an issue with your probation, you'll have to go to the judge that sent this case to me to. Calling 2024 CR 0254, State of Texas versus Michael Anthony Perez. Can I have parties announced for the record for the state?
Daniel Escobar, State of Texas.
Defense?
Freeman Martinez.
Are you Mr. Perez?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count 1, intox manslaughter, and count 4, aggravated assault with deadly weapon, and we're waiving count 2 and count 3.
No objections, Judge.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
All right, off the record. So state and defense, if y'all will write here that the intoxication manslaughter is count 1, and then just do a comma, count 2, aggravated assault with a deadly weapon. So,
Yes, Judge. Sorry about that.
oh, no problem. So did you understand in count 1, you're charged with intoxication manslaughter, and count 4, you're charged with aggravated assault with a deadly weapon? Those are second-degree felonies. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine in each count. Did you understand?
Yes, Judge.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, The fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Judge.
Did you understand by entering this plea you were giving up those rights?
Yes, Judge.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Judge.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Has anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, Judge.
Are you a U.S. citizen?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Off the record for a moment. This is attached to the court's file.
Was it a CD here?
Yes.
Yes, Judge, that should have been in the stipulation.
Okay. All right, we're back on the record. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, you're to plead to counts 1 and count 4. Punishment is to be assessed at 12 years in the prison. There are no applications. And if you are not present for sentencing, you're subject to the full range of punishment. Did you understand that would mean that if you do not appear, then your plea would stand and the court could sentence you to the full 20 years? And that would still be a part of your plea bargain agreement. Did you understand?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Judge, the only thing I didn't hear you mention was the affirmative finding of a deadly weapon.
Yes, there's an affirmative finding of deadly weapon. Did you understand?
Yes, Judge.
Defense?
Yes.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Your Honor.
Then to count 1, how do you plead? Guilty, not guilty, or no contest?
No contest.
Count 4, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states exhibit 1 and all attachments.
No objection, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Judge.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty in count 1. Court will find you guilty in count 2. I'm sorry, count 4. And the court will find there is an aggravated, there is an affirmative finding of deadly weapon. And you are requesting that sentencing be at a different date, counsel?
Yes, Judge. What I'd like to point out to the court, even though it looks like this is a really old case, it just got indicted this year, 2024. We had a plea deadline very recently. We finally got a plea offer. We reached a resolution fairly quickly for a case of this nature. And I'm telling you all that so that you would understand my client didn't have a whole lot of time to start getting his affairs in order. He totally understands the admonishments in the plea agreement. He's single. He needs to dispose of his assets. He needs to leave property with his family. He's been self-employed for many years, and so he's closing down the business. So there's a lot of things that have to be done. We're asking for a date in July, Judge.
All right, I'll give you July 27th. We'll see where we are at that point in time.
Perfect.
All right, is there anything else from either side?
All
right, once you sign the reset form, you are excused. Court is calling 2023 CR 11529, State of Texas versus Abel Martinez. Can I have parties announced for the record for the state?
Anyways, welcome to State of Texas.
Defense? Dan Kramer. Are you Mr. Martinez?
Yes, ma'am.
All right. The reason why you were appointed an attorney is because the court received a report that there's a request for restitution. And I wanted to make sure that you had an attorney for this hearing. Ms. Kramer, are you prepared to proceed?
Based on the information that I was provided, it seems fairly simple, so yes, I'm ready to go.
All right. State.
Your Honor, just from the information that we were able to get, my understanding is that the complainant was stating that there was $1,000 that was in the vehicle, whatever it was verbally, and that we never got restitution back for that. In addition, my understanding is that there were amounts that weren't covered by his policy with employer's insurance. The complainant, as it appeared to the state, did submit paperwork showing the withdrawal of money from the ATM back.
I'm sorry, didn't hear you.
Sorry, the complainant did submit paperwork showing that there was a withdrawal of money in the amount of $1,000 on that date. And at least according to the state, from reading the police reports, it does indicate that he did complain about his new fee. So this isn't a new thing that he brought up.
All right. Any objection to the court reviewing the documentation?
Not at all, Judge.
All right. So the court is reviewing the documentation, and it shows that there was a transaction, an ATM withdrawal on August 17th at 17:02 for $500, and another withdrawal from the ATM on August 17th at 17:03. Both of those withdrawal amounts, I'm sorry, were $500 each. And does anyone know the alleged time that this offense occurred from the stipulations?
I just have the supplemental, so that would have to come from the state.
If there are no objections, I'm looking at the supplemental. And the supplemental, they have August 17th as the offense date. And in the stipulations, it says the occurrence of the event was 1845 with end time of 1935. So
On the same day?
yes.
But what is that, like 6:30 to 7:30?
Well, the complainant is showing a withdrawal from the ATM on August 17th at 17:03.
And that's like 7 o'clock
That'd be
That's 5.
PM? Okay.
Yeah. And then the incident, according to what's in the stips, it has August 17th, and the time frame is 1845, which would be 6:45, and the end time is 1935. Yes.
Okay, and Judge, if my turn? I don't know if it's-
Yes.
As far as the supplemental, I think it says 1,200. In any event, I mean, circumstantially, we don't have any real proof that this money was in the glove box. Anybody could basically, say, oh, I want this money, I put it in the glove box, and, we don't have any idea if it was taken or not. I would think that there should be more than just some, I don't know, unsworn statements from them that this money was in the glove box, alleging that he took it. Secondly, as to the proof from that the insurance company didn't cover the window replacement of 450, documentation of that would be nice. I haven't seen anything like that where the insurance company did not cover that. So barring that, I would say that the court should, at least at this point, order the payment of the 450 either.
All right. So with regards to the $1,000, which is the ATM withdrawal of 2 ATM withdrawals, $500 each, the court is going to order the restitution for the $1,000 for the ATM withdrawals. With regards to your argument about what the insurance did not cover, do you have any proof of that?
Judge, I could look in discovery right now. I just didn't have a moment.
All right. If he is able to provide that, then the court will hear any arguments for why the court should not consider it counsel.
And so at this point, it's not ordered, and we'll have to have another restitution if it gets provided?
Yes.
Thank you, Judge.
All right. So you're going to be ordered to pay the $1,000 restitution to the complainant. Do you understand?
Yes, ma'am.
All right. Is there anything else?
No, Judge.
All right. Thank you, Ms. Kramer. Yes. And Ms. Kramer, make sure that you receive the appointment order.
Yes, I don't think.
If you
Norman's
can come
not
back
here yet,
this
I'll have-
afternoon.
Okay.
All right. Thank you. I'm not the person who placed you on probation. It was another judge. I can tell by the legible writing that it was not me who wrote this. You are not a citizen. You are not allowed to be in the United States unless you are here legally. Do you understand?
Citizen.
Yes, Your
All
Honor.
right. I understand that you have a family here. I understand that you work here. I understand that you've been paying taxes here, but you have to be in the country legally. So the state withdrew the motion because they are saying that the allegation in the motion predates the motion to revoke. So it would be unfair and illegal for me to hear a motion to revoke alleging that you committed an offense prior to being placed on probation. Do you understand?
Sí, su señoría.
Yes, Your Honor.
So you are not allowed to come back to the United States unless you are here legally. If you are here illegally, that is going to be a crime, and that's going to result in a motion to revoke being filed. And with that motion to revoke being filed, if the court were to find it true, the court could sentence you up to 10 years in the prison. And then what would end up happening is you may end up being sentenced to prison. And then when you're released from prison, you'll be sent back to your country of origin. Do you understand?
Sí, su señoría.
Yes, Your Honor.
So if you wish to be in the United States, you will have to do it legally. Do you understand?
Sí, su señoría.
Yes, Your
All
Honor.
right. Do you have any questions about anything?
¿Cuál es el proceso a seguir?
What would be the next step in the process?
Oh, what is going to happen is they're withdrawing the motion. So this case will not be holding you here, but the federal government may be picking you up to deport you. But that is not within my jurisdiction or my purview. Do you understand?
Sí, su señoría.
Yes, Your Honor.
Now, if for some reason the federal government does not pick you up and deport you, you will still need to report to probation. If you do not report to probation, then a motion to revoke may be filed. If you are deported, it would probably be best for you to pick up the phone and call probation and let them know you have been deported. Do you have any questions?
Sí, su señoría.
Yes, Your Honor.
What are your questions?
Entonces todavía tengo una, ¿cómo se dice? Una aprobación. Todavía estoy en aprobatoria.
So, then I still am on, and how do you say this? I'm still on probation.
Yes.
Sí, está con autorización de libertad o libertad condicional.
The previous judge gave you deferred adjudication for 4 years. And counsel, 4 years. And counsel, are you appointed?
No.
You were okay. The reason why I asked that, counsel, is because if you're appointed, there's an immigration attorney right behind us. And I'm sure if needed, because I don't know if you do immigration or not, she can probably explain to him potentially what may happen. All right. So if you could help and let him know what the process is. The motion to revoke has been withdrawn because the illegal reentry predates the date of the motion. I'm sorry, predates the date he was placed on probation. So he's not here legally. So he's wondering what will happen once this is withdrawn. And I don't know the entire federal system as it relates to that. I always tell people immigration is a specialty of its own. It's like bankruptcy law. Don't get involved in that. Don't get involved in immigration unless.
And just like that, it was over. Every decision, every argument, and every moment led to this outcome. Whether you agree with the sentence or not, one thing is certain, this courtroom won't forget this case anytime soon. Now I want to hear from you. Was justice truly served, or would you have made a different decision?